planned studies.
Yes, yes. So we'll start. Dr. Jagruti, you can start.
Yes, ma'am. Yes, thank you. So, good evening, everyone. I feel extremely glad to welcome everyone to our first webinar of this webinar series by NIMA OBGY Central. Myself, Dr. Jagruti, coordinating today's webinar with Dr. Abhishek. Before starting our session, I request all the dignitaries and all the participants to take a moment for blessings of Lord Dhanvantari. शङ्खं चक्रं जलौकां ददतमृतघटं चारुदूर्भिश्चतुर्भिः सूक्ष्मस्वच्छातिरुद्यां शुकपरिविलसन् मौलिमम्भोजनेत्रं कालाम्बोदोज्ज्वलाङ्गं कटितटविलसच्चारुपीताम्बराढ्यं वन्दे धन्वन्तरिं तं निखिलगदवनं प्रौढदावाग्निनीलं प्रौढदावाग्निनीलम्. So, may Lord Dhanvantari bless us all with good health and success. Let us continue and begin this webinar. On behalf of NIMA OBGY Central, I welcome all the dignitaries and delegates for today's knowledge enhancing session on the topic of medical legal aspects of the consent. First of all, I welcome all the dignitaries of NIMA Central. Then I would like to welcome Dr. Kamini Dhiman ma'am, President of NIMA OBGY Central, Dr. Priyanka Nakte ma'am, Secretary of NIMA OBGY Central, Dr. Vishnu Bhavne sir, Treasurer of NIMA OBGY Central, Dr. Rajesh Utne sir, Convener of NIMA OBGY Central. Then I would also like to welcome all the dignitaries of NIMA OBGY Maharashtra. So before we go any further, let me give you a few instructions regarding to the session. So please keep yourself muted during the session. If your mic found unmuted or disturbing with the speaker's voice, you will be either kept in waiting room or removed from the session to maintain decorum of the program. Today, we are very lucky to have here with us a distinguished personality, Advocate Dr. Arun Mishra, sir. So we welcome you, sir. We are honored to have you with us. If It is my pleasure to introduce all of you to Advocate Arun Mishra, sir. Advocate Dr. Arun Mishra, sir, is a practicing advocate in Supreme Court, High Court, and widely known medical legal consultant. He has completed LLM from Mumbai University. He also has his credit three different graduations in microbiology, medicine, and law, also different post graduations in medicine, law, and in yoga. He founded his organization with the name Doctors Risk Medical Legal Services in 2003 and helped thousands of professionals in last 20 years. Further, for understanding the human nature, he has done his master's in psychology, master's in arts, PG in mythology, PG in mysticism, advanced course in yoga, and many more from Mumbai University. He has authored 8 books on law of medicine and other in philosophy. Having successfully handled almost 18,000 medical legal cases in last 20 years, he humbly attributes his practical and combined knowledge of the medicine and law. In the field of medical legal, he is arguably the best among its peers in India. His success rate counts as on today is almost 100%. So, with due respect, I would like to call upon Advocate Dr. Arun Mishra, sir. Welcome, sir.
You. So thank you, Abhishek. Thank you, Jagruti, for introducing me, and thanks Dr. Priyanka and their team for inviting me to this session. I know this is a very important session, and I really thank every delegates here who have spent the time to listen to this session. You will understand how important session is for you all. Prior to that, let me thank a complete team of NIMA, from central NIMA to the state NIMA, who always think of their people, protect and defend them in every scenario situation by various methodologies, whatever they instruct. And I really appreciate the effort of central NIMA and state NIMA and their real people behind the president, secretary, and all sort of a committee member, and the people who are concerned about their people to initiate the series of knowledge imparting to their people to safeguard themselves. My friend I say this because I am very fond of education. I know with the knowledge you can replace your ignorance and you can have a very confident practice. So today, definitely, I will try my best to give you the settled law of the country in respect to the consent, so that with this particular knowledge, hereafter you can do your practice very confidently without any fear, with all peace in mind. I'm definitely open to the question answer session when I finish my session, so that I can learn from you. I can give a lot of my experience, knowledge of 20 years to you in respect to medical law. So with this background, let me start this session for you all. Very, very important session which was planned today for my people is that session on the part of a consent. Yes, my friend, consent. It is much said in this particular country about the keeping of medical record. And this is my personal experience, which I always say that keeping a medical record is essence for every single medical practitioner. In that domain, one of the document in medical record is a consent paper. Let me tell you honestly, my friend, the written document, which is known as a medical record, is only piece of evidence which my doctor has got in every court of law. Let it be in medical counsel, let it be in consumer fora, or could be in criminal cases. Your medical record only read and oral does not have got value when there's written and medical records. That's the reason why medical record is a very, very vital. And when I talk about consent, consent plays a huge, huge important role in our country. This has been narrated in every judgment of this honorable Supreme Courts of this country, where they categorically has mentioned the importance of a consent wherever they have found importance of that, in which we are going to discuss one case, which is of Samira Kohli versus Prabhanand Chanda today, to make you understand the settled law of the consent. Prior to that, let me give you guidance. When we talk about criminal liability in a medical practice, yes, my friend, criminal liability in medical practice plays a vital role to safeguard my doctor. In criminal liability, again, the consent plays a vital. This is not only been settled law under this IPC Act, but also been referred in multiple judgments of Honorable Supreme Court. If you go and read the general exceptions defined by the Parliament under the 1860 IPC, right from section 86, 87 to 91, they have elaborated the importance of consent. Let me give you one very clear wordings of this particular act. It says that any act done in good faith with the consent of a patient for benefiting or giving a life, and if at all any medical mishap happens, including the death, doctor must not be held responsible. They have given an illustration of a doctor also in that. In minor, they have very clearly narrated with the consent of a guardian or with the consent of a parent. In unsound mind or intoxicated patient or unsound mind minor, these people's consent plays a very vital role. And Honorable Supreme Court, in judgment of Jacob Matthew, have narrated these sections again to protect doctor from criminal liability. And they have interpreted every section of IPC while interpreting 304A of IPC, which is normally applicable to the doctor in case of a death, which says that causing a death without intention with a negligent act, which attracts criminal punishment, definitely has been very seriously taken in this court of law. And Honorable Supreme Court said that criminal liability has already been given there, where protection has been given to the doctor under the general exception of IPC. You can understand how important the consent is. So to safeguard you from criminal liability, your own act says, your Honorable Supreme Court says that if consent is properly taken, you will be safeguarded in criminal liability. But when question comes in medical counsel, you go and see the old act of MCI, under which regulation ethics and ethics 2002 had been formed, and now under NMC, the same has been notified and accepted today, because NMC notification of new ethics 2023 has been suspended in August 1. But this plays a vital role, and you will find in CCIMs also the same ethics and ethics regulations. There they have categorically said in NMC, very specifically, which was referred in this particular judgment of Samira Kohli also, and multiple judgment in country, where they have elaborated the importance of consent. And new law has talked much about the consent. And when they talk about the consent, they have gone a step ahead, and they have said in a case of infertility, consent of both the partners are mandatory. So even the medical councils who have defined the act, regulation, and rules categorically talks about the consent. And when I talk about civil liability under the law of torts or under the law of consumer fora, consent become very, very important, because in my personal experience, in the past, multiple judgment has been delivered on the ground of consent only, either in favor of a doctor or in favor of a patient. Let me give an example. So let me give an example of one of the case where hair removal through laser was done by the cosmetic center. The sitting doctor has increased the frequency of laser, which leaded to skin burn. Patient went to the consumer fora. Only difference which doctor has shown to the consumer fora is a consent paper. And according to them, they said, I have already explained the possible complication to the patient prior to the surgery. And she has read it and signed it in respect to the same. Once she got complication, got treated, there's no negligence on my part, and court has accepted that defense and exonerated doctor from all charges. So that is the power of consent, my friend. That's the reason consent plays a vital role. Now, with this background, let me come and discuss about today's session, which is based on settled law of the consent in this country. When I say settled law, yes, it got settled because Honorable Supreme Court has already decided the case, and judgment has been delivered in 2008. Yes, my friend, this was a case of Samira Kohli versus Dr. Prabhachanda and others. In this case, the earlier consent which was been adopted in this country has been outdated, and the new guidelines has taken a place of the consent. In this case, let me give a brief story what happened and how this case got decided and proceeded. This was a case where a patient with metrorrhagia and dysmenorrhea, that is profuse menstruation bleeding of 9 days, that is a patient name was Samira Kohli of 44 years age, unmarried lady, approached Dr. Prabhachanda and her team for purpose of a treatment on 9th May 1995, the case of 1995. And that time, doctor has examined her and looking to the condition, immediately advised to go for sonography because lots of tenderness was there on abdomen. Doctor could feel the mass. Looking to that, they immediately advised to go for ultrasonography. Ultrasonography have shown fibroids and multiple cysts, which leaded to go for naturally diagnostic through laparoscopy. This was well explained to the patient. Counseling was done by the doctor. According to doctor, the final things they can judge when they do a diagnostic test And for that, they called on next day. The next day, patient approached the doctor. Doctor has taken all possible consent which was there, including the consent for diagnostic, laparoscopy, SOS laparotomy, with, if needed, laparotomy. And all other consent was taken. Doctor has taken a patient for the procedure. During the procedure, doctor found the need of removing the uterus because of multiple factors. According to the doctor, because of endometriosis, which has got extension in future, can lead to impacting intestine or a bladder, or could be in rare case the cancer. She thought that why not remove the uterus? According to the patient, this was a made up story. There must be some complication happened during the procedure. That's the reason as when patient was unconscious, the assistant went out and taken a signature of a mother in misconception, saying that her life is in danger. If at all we don't do immediately hysterectomy, she may die. And consent for hysterectomy with removal of ovaries and fallopian tube has been taken by mother, and patient surgery was done. Fourth, fifth day, according to the patient, she came to know on 14th May, that is 15th, she got discharged, that her uterus was removed without her consent. On 15th, patient has not paid the bill, left the hospital. There the conflict happened between both the people. For want of money of 29 or 39,000 rupees, doctor has sent a civil notice to the patient for recovery of money which was not paid to her. And in counter, patient has filed a consumer complaint for want of 25 lakhs rupees for unlawful, unwarranted, unauthorized removal of uterus. According to her, her uterus was removed without her consent and she became infertile. She was going to marry a 1 month later. She was going to get pregnant thereafter. Now her motherhood has been taken away. Not only that, she need to go for hormonal therapy because of premature menopause due to this surgery, which was unauthorized, unlawful, not consented, and that is a negligence on the part of a doctor. This was the basic case. Both the parties have presented them in all the respect, and finally, court need to decide about the case. The more important question came in mind of a court to decide in this particular matter, which was been defined. So let me show you the judgment and the question which came in the mind of court to decide this matter. So the four important question which came where court thought of deciding the matter was, after hearing both the cases, which court has actually considered it and decided it, was, let me read for you so that you will understand this judgment properly in better way. First question came to be decided whether the informed consent of a patient is necessary for surgical procedure involving removal of reproductive organ. If so, what is the nature of such consent? This question came because the MCI was having a settled law that when the question of infertility comes, both the partners' signatures are mandatory and needed to be taken. Now here other partner was not there, but this question of infertility, have this consent was properly taken. When patient consults a medical practitioner, whether consent given for diagnostic surgery can be constructed or construed as a consent for performing additional or further surgical procedure, either as a conservative treatment or as a radical treatment without the specific consent of such additional or further surgery. Now, in this case, what was happened? The doctor has defended herself saying that additional consent was already taken, which was of laparotomy. Court has not only observed the medical record, very deeply, deep-rootedly gone to every single paper submitted to court, but also decided the case on the basis of expert who has given an opinion in particular. From patient side, one gynecologist who was openized has very categorically clearly said that on sonography, it is very difficult to diagnose endometriosis because that was the only difference which Pravachanda has taken. The doctor from the patient, the doctor from the doctor's side or hospital side has very categorically said that yes, it cannot be diagnosed on USG, but laparoscopically when diagnosed, surgery was definitely needed. Now, question came, is laparotomy and hysterectomy is same? Because consent was taken for laparotomy and surgery was done of hysterectomy, and where court has gone through every aspect and finally decided that since both the procedures are different, consent taken as laparotomy cannot be used as a consent for hysterectomy. So, whether there was a consent by appellant for abdominal hysterectomy and bilateral, of course, salpingo oophorectomy performed by the respondent, whether respondent has falsely invented, like this was a claim, the doctor has falsely said that there is a life-threatening disease, invented a case that appellant was suffering from endometriosis to explain the unauthorized, unwarranted removal of uterus and ovaries, and whether such radical surgery was either to cover up negligence in conducting diagnostic laparoscopy or to claim higher fees. Even if appellant was suffering from endometriosis, respondent ought to have resorted to conservative treatment of surgery instead of performing a radical surgery. Whether the respondent is guilty of tortoise act, of negligent battery amount to diffuser services, and consequently liable to examine. This was a question which got decided, which got discussed under the domain of this judgment. And what happened thereafter? Consuls from both the sides has submitted lots of judgment of foreign countries in respect to the consent, including the judgments delivered by Honorable Supreme Court in various other matters, and also academic book, and also the affidavit filed by both the side doctors with their opinion, and very deep discussion on every point has been done under the judgment. My humble request to all my colleagues here, please go and read complete judgment. I'm just trying to give you a gist so that we can save a time for the question answer. Now, in spite of all discussion, finally court came very heavily against the doctor, and they have very categorically said that laparotomy and hysterectomy is two different procedures. They said when there is a possibilities of conservative treatment, doctor should have closed the abdomen. Since patient was unconscious, she was not able to give a consent. Her mother consent was not important there, and he should have given opportunity to the patient to take a call for going for hysterectomy or not. This was the observation done by the court. According to court, except in emergency scenario, you can't take away the rights of the patient, rights of the consumer. That was the observation done. And finally, court came very heavily, but tried to balance both the parties. So given a compensation of only 25,000 rupees and also instructed hospital, if they have already recovered the fees, they should return all the fees which was charged to the patient. So damage and the refund is very small amount, but law got settled under the domain of this particular. And hereafter, the law of consent got settled with the guidelines given by the Honorable Supreme Court. So let us understand the guidelines which court has given. So let me share you uh, as a critical part of a judgment which every doctor must know in this particular case. And this is what court has observed and which you all have to mandatorily observe during your day-to-day practice. This you need to very seriously take during your practice hours every time when you take a consent, because this is going to be referred in every cases in court of law by opponent advocate while arguing the matter against you or in favor of you if I argue the matter. Now, what are the principles laid down by the court under the judgment in 2008? Now, what they said, we may now summarize the principle relating to consent. So, it has been settled now. What principle? A doctor has to seek and secure the consent of a patient before commencing a treatment. And they mentioned the term treatment includes surgery. So, you need to take a consent. Now, implied consent, they have already said. There is a implied consent when we come for the treatment, but you need to have an express consent when there is a procedure done. The consent so obtained should be real and valid. What they said, it must be real and valid, means you need to give a complete information, which means that patient should have the capacity, means above 18 years of age, conscious, adult, and competence to consent. His consent should be voluntary, so there should not be any pressure. She or he should voluntarily sign, and his consent should be on the basis of adequate information. This was a word which was interpreted thereafter in every law. So information must be given adequately prior to taking a consent concerning the nature of the treatment, procedure, so that he knows that he is consented to do what. So even the nature of the procedure you need to explain. So what they said about adequate information, the adequate information to be furnished by the doctor or a member of his team. So anyone can do. Now, question comes that can HOD only need to explain the patient? No. Even the houseman can explain. So any member of the team can give information. Who treat the patient should be enabled to patient to make a balanced judgment. Like in your case, RMOs and other people who take the consent, but not receptionists, because the question again came, are she is medically known to the things. So now what they said, patient to make a balanced judgment as to whether he should submit himself to the particular treatment, as to whether the submit himself to particular treatment or not. This means that doctor should disclose. Now this is very important, which has been repeatedly been discussed in every session by every doctor, speaker. What it said, nature and procedure of the treatment and its purpose, benefit and effort, alternatives if any available, an online outline of substantial risk and adverse consequential representation. I try to understand 2-3 things in this particular case. One, you need to explain all possible complications. You need to explain the benefit to the patient. You need to explain the alternative to the patient, and you need to take a refusal consent. Now, alternative, if at all, there possible. And refusal consent means what? Suppose they have not agreed to your advice of the first. Now, what court wanted? But there is no need to explain remote or theoretical risk. So, you are going to die. That is remote or theoretical risk. You may go to DIC. There's no theoretical risk. So, court said you need not have to explain all this. Refusal to have consent for necessary treatment. So, you should not explain the remote or theoretical risk involved, which may frighten or confuse the patient. So, if you say you are going to die, they are going to get confused and result in refusal of consent for necessary treatment. Similarly, there is no need to explain the remote or theoretical risk of refusal to take a treatment, which may persuade patient to undergo fanciful unnecessary treatment. So even if at all it is there, don't return him, don't frighten him. So they said that you need to balance it. A balance should be achieved between the need for disclosing necessary and adequate information and at the same time avoid possibilities of patient being deterred for agreeing to a necessary treatment or offering undergo unnecessary treatment. So they are very clear. They are very clear. Consent given only for diagnostic procedure cannot be considered a consent for therapeutic treatment. So you cannot immediately change your wording that this is going to give a consent. Consent given for specific treatment procedure will not be valid for conducting some other treatment procedure. The fact that unauthorized additional surgery is beneficial to the patient. Many of the we do say the life of the patient can be saved is not going to be defense. Court says the unauthorized additional surgery is beneficial to the patient, or that it would save the considerable time at the expense of the patient, or would relieve the patient of the pain and suffering in future, are not the ground of a defense. In an action in tort for negligence, assault, or battery. The only exception, what they say, to rule is where the additional procedure through unauthorized, if unnecessary, in order to save the life of the patient. Now, suppose you are doing a laparoscopic surgery and injuries happened, perforation happened. Now, this is going to be the definitely a life-threatening situation, or because of bleeding, that life is going to be stake. In that case, you can definitely go. But where it is not life-threatening, you should not have that defenses. So, if it is a life to preserve the health of the patient and you would be unreasonable to delay such an authorized procedure until the patient regains consciousness, you can take a decision. There can be the common consent. So, court has given further one step and protection to us. There can be common consent for diagnostic and operative procedure where there are a contemplated. There can be also be common consent for particular surgical procedure and additional for further procedure that may become necessary. So you can take in advance a consent for possible surgeries if required. There can be common consent at the set where there are contemplated. The nature and extent of involvement should be furnished by the doctor to the patient to secure consent need not be a stringent. So you should not fear the patient. And high degree mentioned in Canterbury because Canterbury law is very strict. They said you have to explain the death also, which was not been advised in our country, looking the scenario in our country, but should be extent which is expected as a normal and a proper by the body of medical men skilled and experienced in a particular field. It will depend upon the physical, mental condition of the patient, nature of the treatment, risk, consequence, and attached to the treatment. Court is very clearly has guided that what need to be done. Court is very clear while describing. Court is very clear while describing the consent principle. So let me summarize for you all people. If you understand this particularly the principle, what court wanted to say that you need to explain a patient the procedure itself and the benefit they are going to get. You need to explain possible complication, not very theoretical complication, not to frighten the patient. You need to explain alternative if it is available. Like you're going for LSCS, but there is a possibilities of uh, forceps delivery or could be vacuum delivery. You can balancedly talk about this thing and their complication also. And if at all they refuse your cesarean go for vacuum, you need to take a refusal consent for your protection. So these are the things which very clearly been defined under the law, my friend. And after 2008, the law of consent got settled. And furtherance to that been followed in multiple judgment. And one more judgment which came, I may take in, if at all there is going to be a series, was of latest law of 2020, where under the domain of consent, pre-printed consent form was taken as a question where RG Stone was relieved from medical negligence. But since blank, court has observed that pre-printed blanket consent form having a space of signature of patient and witness is high headness of the hospital, arbitrary of the hospital, and unfair trade practice and 10 lakh penalty. So that is again the judgment is going to impact the consent and many more things which has been decided and defined under the domain of consent. And multiple judgments are also coming where we are losing the case because we are not very serious in maintaining the consent. Implied consent definitely is going to go good for you when patient comes and taking a treatment from you. But the moment you go with the procedure, you need to take a written consent. My friend, in short, let me tell you about the consent. Three signatures are very important in consent. Doctor's signature, patient signature, witness signature. It becomes a complete contract. Absence of any signature can lead to a problem. If there is a translator, witness signature of translator must be taken. If any three person, whoever has written in vernacular language, signed in vernacular language, if Marathi or Hindi, you need to explain or write in Hindi or Marathi also, because tomorrow in court of law, they say that we don't know English. So lots of question comes. Even some impression challenge. I was arguing the matter in National Commission. I could able to get a benefit from my anesthetic friend for whom I was appearing, but the surgeon been compensated, given order to compensate 10 lakh rupees in a case where only question of thumb impression on a consent paper found, where the complainant has said that my wife, that was in TL surgery, where patient died post TL surgery, where the complainant said my wife was school teacher. He has submitted the register of a school where she was seen as signing. He said that she, being a postgraduate student, knows how to sign, and thumb impression on consent paper definitely has been taken by the doctor post her death to wipe up the things, and which court has accepted, and 10 lakh penalty was given. So lots of things are happening, court of law, my friend. My humble request to all my practitioner here to be safe, be secure, be conscious while taking a consent from the patient. I know this is going to be a topic which is going to go on, but I know that many of the doctors definitely got multiple questions in their mind. I love to interact with the people so that I can pass my knowledge and experience in domain of that. I open a forum, Abhishek and Jagruti and Priyanka ma'am, if at all any questions are there with the audience, we can discuss and we can have a more idea, information, or understanding about the consent. One question I have found in the chat box, Dr. Shuranshi Nitin has asked, a patient says, I signed a consent without reading it properly. Kindly add further possibilities. This is a very common thing. Patients are going to say that. But law says that if you signed, it is deemed that you have read it. So not to worry about that. Like in many of the bank loan or many of the time where you sign, you don't read the paper. You being a beneficiary, even if you take a SIM card, you don't read the form, you just sign it. You go to any application, terms condition, you say, I agree with the terms condition. You never read a terms condition. In a bank loan, you sign all the document without reading the document. But when in court of law, it's all paper goes, it is deemed that you have read it. So a patient takes the ground that I have not been explained, you do not have to worry if sign are there. Second, if you got your own witness who has signed the paper, that witness can be a protector to you, saying that yes, the signature was done in front of me. Doctor has explained the same to us in our language. So double benefit you got with the witness and also with the law. So not to worry anything, that is going to be safeguarded. और अगर कोई क्वेश्चन है तो आप मेरे से पूछ सकते हो. जागृती, अभिषेक, कोणाला काही असं विचारायचं असेल तर त्यांना ओपनली इन्व्हाइट करा.
Yes,
अंडरस्टँडिंग
everyone.
वाढेल आणि आपल्याला आणखीन त्यामध्ये समज भेटेल. हा, अभिषेक.
Yes,
Yes,
everyone are
Abhishek.
requested. Everyone are requested to put your question in chat box, or you can ask directly.
You can ask me directly also, unmute yourself and can ask, or you, if you want, you can put in chat box. If nothing is there, so I think you have understood properly. And in next series, if at all it is going on consent or any other part, I will definitely come and give insight of something else also, so that you will be benefited with that.
So, actually, I have one question.
Please, please, please.
So,
What's a good name?
Dr. Jagruti, sir.
Yes, Jagrati. Yeah, please, please, please tell me.
Sir, the case has happened. Actually, I don't know the details of the case, but the ANC come to the doctor, and as routine, we have the doctor has suggested anomaly scan or first trimester NT scan, dual markers, quadruple markers. Everything was clear-cutly normal. And after delivery of the baby is diagnosed as a Down syndrome, and patient has charged the doctor and radiologist for the negligence.
Not to worry about that, Jagrati, because see, the first thing is that you are going to give a treatment advice or whatever is on the basis of radiologist report. And there's no chance that you can diagnose it without that. So clinical diagnosis in such a scenario definitely become a great defense to us. A radiologist have to defend himself that why and what reason he missed. Now there is multiple ground in radiology also. So major, see, there is a limitation in radiology also, sonology also, because we are doing with the probes. Many of the things, something missed, something been suppressed, something because of the position of the baby, something because of the amniotic fluid, or maybe because of any other hidden things get misplaced and does not get reported. So once we have got complete case study in this case, right from antenatal care to the sonograph report and how many sonography and non-normal scan, we can defend the doctor, both the doctors properly report of allegation is going to come. So, but it does not mean that in every allegation you are going to be proven as a negligent.
Okay, sir.
Any other question?
सर साउथ बॉम्बे में एक केस हुआ था, केस डाला था डॉक्टर के ऊपर। हम हर एक तरह का कंसेंट लेते हैं, सर्जरी का, एनेस्थेशिया का, पर जो माइनर थिंग रहती है उनका हम कंसेंट नहीं लेते। वो पेशेंट ने ऐसा केस डाला था कि ऑपरेशन के बाद, सेक्शन के बाद मेरे पर रेक्टम जो कुछ सपोजिटरी डाला है वो मुझे बिना बताए हुए डाला था। तो उसका उसने केस डाला था। तो ऐसे में भी इतना हम माइनर जो थिंग करते हैं उसका भी कंसेंट लेना जरूरी है क्या?
बेटर है, क्योंकि अभी माहौल बदल रहा है। अभिषेक, कोर्ट ने क्या बोला है कि इम्प्लाइड कंसेंट बहुत इंपॉर्टेंट है, ट्रीटमेंट एक्सपेक्ट करता है और आप देते हो। लेकिन कोर्ट ये भी बोलता है कि जब आप उसके बॉडी को टच करते हो और यू आर गोइंग टू डू सम प्रोसीजर ऑन हर बॉडी और हिज बॉडी, तो इट इज बेटर टू हैव अ कंसेंट, एक्सप्रेस कंसेंट। तो मैं आपको बताऊं, ब्लड ट्रांसफ्यूजन का कंसेंट नहीं लिया था, दैट इज अगेन अ माइनर प्रोसीजर बीइंग स्पोकन, वेयर हॉस्पिटल हैज बीन पेनलाइज्ड टू गिव 5 lakhs। तो प्रोसीजर की बात जब आती है तो इट इज बेटर टू हैव अ कंसेंट फॉर प्रोसीजर, इट इज एनी टाइम सेफ गार्ड। रही बात है साउथ मुंबई की केस की, चूंकि केस को पूरा अगर जब तक पढ़ेंगे तो बहुत कुछ समझ में आएगा, तो उन चीजों के हिसाब से उस केस को अच्छे से डिफेंड किया जा सकता है। लेकिन आने वाले दिनों के लिए, आने वाले अपॉर्चुनिटीज के लिए मैं सभी डॉक्टरों से यही रिक्वेस्ट करूंगा कि आप सब लोग कोशिश करो, माइनर प्रोसीजर हो या कोई भी प्रोसीजर हो, आप कंसेंट ले लीजिए, कीजिए, आपके लिए बेटर हो। Manoj Sinha has asked in chat box, if CBD injury happens during the colostomy, then how to inform and how to take the next concern. Not to worry, what's wrong? See, Honorable Supreme Court has said that you are not a god. Your Honorable Supreme Court has said that medical science is a complex science and human body is a complex machine. So you are not going to give a life to every single patient. And complication which has been given in academic book has been accepted. So there is a possibilities of injury. You're not got that you're, but if it has happened, so don't get panic. You intimate to the patient. If it is life-threatening, as I said, if there is a life-threatening scenario situation, even if you don't have a consent, you go ahead and do the surgery and make it good. And later you explain the patient the truth, whatever is there. That is going to be medical record. Now, otherwise also, as we have already seen, you can take one go consent for laparotomy also in or any possible surgeries hereafter. So don't worry, you can be very well defended. Prajakta Party, medical legal laws regarding professional fees. See, there is no law, settled law. There is a
Hello.
chartered accountant, company secretaries, advocates, doctors, being a professional, does not have any limitation of capping. So professional fees, you can ask any amount. There's no question on that. Kindly remember the case about the PPH after LSCS in which the doctor committed suicide. See, basically in that case of suicide of Rajasthan, it was allegation put forth on a doctor that she has murdered the patient. If you have read the newspaper and media, because it became a media trial in that case, my doctor got feared because she was ignorance about the law. She was not knowing that nothing is going to happen to the doctor because Honorable Supreme Court has protected doctor in case of medical mishap. And Honorable Supreme Court has said that it must be gross negligence. And further they said it must be organized by the committee prior you arrest a doctor. But in Rajasthan case, it was a fear because of ignorance, and no one has given a proper guidance to that lady. And every time media trial was there, politicians got involved. Earlier, they created the story of murder. Later, they have created a story of 304, that is 10 years punishment, causing a death without intention with the knowledge. And these all being pressure on a lady doctor who was innocent and whole life she has not faced any issues. And because of the pressure of getting arrested and ignorance, she has committed suicide. That was absolutely wrong. My humble request to all my doctors sitting here, if your colleague, your friend, anytime get any such a scenario situation where he get really trapped in a scenario where there is a possibility of arrest, please guide them that law of the land is settled. No doctor is going to get arrested without committee opinion. So immediate arrest is not possible. Just pass the knowledge to them. Believe me, you can save many of doctors' life with your knowledge. So Abhishek, there is no further question, and I
Hello,
think if there's no question, then yeah, please.
sir.
Ali, yeah, please.
The next
Yeah, please.
Yeah, good evening, sir.
Yeah, beta.
Being Ayurveda, we're doing Panchakarma as well, along with surgeries, minor surgeries as well as we're doing minor Panchakarma at our ease. So, being MS MD Ayurveda, while doing Panchakarma, also we are bound to submit that consent form
Yes,
before doing all the Panchakarma.
yes, beta.
So,
Panchakarma, yeah.
yeah, like Uttar
Panchakarma is also a
Bhatt,
procedure, beta. Try to
procedure. Yeah,
understand. I have got
yeah.
multiple cases in respect to Panchakarma where proper history is not taken. In case of one case of Basti, where already patient was suffering from intestinal ulcer and cancer or something like that, and
Yeah,
Basti and that
yeah,
it was treated to death. I got a
mm,
case where Panchakarma has treated not because of Panchakarma, but patient was already having a blockage. No proper history was
exactly.
given.
Yes,
I got a case of liver treatment where naturally enzyme has gone raised, but allegation put forth on a Panchakarma doctor. I got a case where plasmas were been commented that metal poisoning. So cases are coming to the state to that. My humble
okay.
request that if you are doing anything, take a proper history. Please do a
Mm,
consult a patient, take a proper consent, and go ahead with the procedure. Not to worry if any mishap happens, because you are
okay,
not a God to give a life to every single person.
exactly. Thank you very much, sir. Thank you.
Okay, beta.
So the next question is medical fitness is necessary in case of emergency LSCS because
No,
sometimes there is no time to take the medical
law
fitness.
is settled under the Indian context that in emergency you need not have to wait for anything, because there's the prime thing is to save the life of the patient. So if you wait for the procedure, even Parmanand Katara's case and Jacob Matthews' case and latest today 𝘾𝘼𝙎𝙀 case I have discussed, in all everywhere narrated that in emergency you do not have to wait, you have to just only immediately act to save the life. So not to worry about the fitness in emergency.
Okay, sir. And if the
Doctor,
patient comes with the head-on perineum and she did not investigated even the CBC or even not single
You can proceed with the procedure. You will be safeguarded, but at the same time, I will request you to send immediately blood investigation so that CBC within a minute also you will get report and life
yes,
will
but
be saved if at all you are delivered and bleeding has happened.
okay, sonography even not there then.
No, but we already got a head and how come you proceed? If nothing is done, not to worry. Go ahead with that, because that is
Okay,
emergency
okay, sir.
scenario.
Okay, sir. Thank you so
He
much.
must have gone to ANC for some other doctor.
Dr. Prajakta Patil, madam, I have
There
one
was a case
question.
when a patient visited a center for weight loss. She was charged heavily and she didn't lose any weight. She filed a case against the center kindly. Not to worry, na. See, false commitment definitely going to picture, and then she need to explain to the court why she has came to the court. Now, charged heavily or not heavily is based on what you have suggestion you have given. You are not responsible for the result and outcome. Court has very categorically said that the advocate also does not give a guarantee that he is going to win 100% of the case. Same way, doctor cannot give a guarantee to give 100% result to every patient, because results it depend upon multiple factors. So even if at all charges have been taken and desirable result is not got by the patient, does not mean that is negligence. So not to worry, doctor need to defend with a better hand and he can be safeguarded or she can be safeguarded.
Next question from Akansha Singh Madam in chat box.
We have already answered. LSCS fitness is not necessary.
Yes.
Elective LSCS, yes, definitely necessary. Emergency LSCS, no question. But in elective, you have to, if at all, any element of or any chief complaint given of the patient of ISD, diabetes or something. If patient is absolutely normal, then I don't think there's going to be any question of fitness in that case.
So while taking the consent for LSCS, we if there is necessary for PPH, we should do the OH, means obstetric hysterectomy. So should we take every time the consent for OH?
Yes, preferably. So in one consent, you can go with all the procedure wherever your expectation is going to be in that side.
Okay.
So Abhishek, I don't think there's any more question. We can take in next session also, as I have been told that series of session you are going to have. So
Sir, excuse me, sir. I have one question.
yeah, please.
Yeah. Actually, I had one case. Patient had undergone incomplete abortion, and she got admitted under me. After doing DNC and all these resuscitative measures, she is admitted 2-3 days at our hospital. But while being discharged, her hemoglobin was very low. So we have counseled her for the blood transfusion and all these things. But they didn't convince, and they're saying like we opted two options, one for BT as well as it was not too low. It is almost 7.5. So we ordered the Orofer injections, that is hematinic injections, that should be given in IV fluids. But patient didn't convince at all. And while being discharged, they are arguing with us. We will come after some days and we will take that all your remedies. And they didn't know about the seriousness. So what if the patient that time they didn't convince and get discharged immediately? So what are the formalities
to
or
give DAMA
what should be
discharge.
DAMA? Yeah, we given, but
Always put a DAMA on that. Mention all
yeah,
everything in the medical record. Your
yeah.
advice given to the patient.
Already
That
we
patient is
already we have say we did the same things, but that time patient has argued and some
they are going to. You can't
yeah
stop patient arguing. We are in a country
foreign
where
yeah
nowadays
about exactly, sir. Medicolegal, I think I forget some like troubles had they had made, and
they are
in
going to.
that
You
concern
can't
only,
stop
yeah,
them. You can't
exactly.
stop patient. Nowadays
So that time
politician and
only
disrespect
DAMA
person.
discharge is more than
You
good.
for your safety, if
Okay.
at all you have advice on treatment and you know that
Yes.
patient is not going to sign on
Yeah.
paper
Yes.
because they are already argued it, so definitely they are not going to sign on a paper. If they
Exactly.
can sign on a
Yeah, I
paper,
remember now. They didn't sign on that
so
DAMA and
that's
all
the
of this.
reason. That's the
Yeah,
reason. That's the
yeah,
reason I said
exactly, sir.
ki when
Yes.
they have already argued, if you are going to explain all the possibilities and they are not going to go for your advice and they are going to refuse to sign, in that
Yes.
case, you mention everything on a medical record and
Yeah,
put a DAMA.
same I did. Yeah, thank you, sir. Yeah, I
Then
remember
DAMA.
that. Yeah.
DAMA means
So,
tomorrow, if at all they come, you have got a good defense to say that.
yes. Yeah, thank you very much.
Okay, beta.
Yeah, sir. Thank you.
Okay, Pranali. So I think everything is fine. Abhishek and Jagruti can be end the session today. And
We are going
let's
last.
meet again. And thank you to all the delegates here who have allowed me to speak. Thank you to Priyanka madam and the team, and very special thank to Abhishek and of course Prajakta who followed me and Jagruti who has introduced me and many more people and all central NIMA team and state NIMA team. Thank you to all and to all the delegates. And let's meet again. Yes, Abhishek, over to you.
Yes. Thank you. Thank you so much, sir. On behalf of NIMA OBGY Central and NIMA OBGY Maharashtra Society, I would like to thank my gratitude to Dr. Ashutosh Kulkarni sir, Dr. U.S. Pandey sir, Dr. Shantila Sarma sir for their remarkable support. I extend my gratitude to our NIMA OBGY Central President Dr. Kamini Dhiman Madam, Secretary Dr. Priyanka Nakade Madam, Treasurer Dr. Vishnu Bhavane sir, and Convener Dr. Rajesh Uttane sir for supporting and guiding us for today's webinar. I would like to thank and extend my gratitude to our eminent speaker, Advocate Dr. Arun Mishra, sir, who took time from their busy schedule and delivered very knowledgeable session. I would like to thank NIMA OBGY Maharashtra President Dr. Suhas Herlekar, sir, Secretary Dr. Manoj Gaikwad, sir, Treasurer Dr. 𝘖𝘼𝙎𝙎, sir, for their support. I would like to thank Dr. Girish Jaga, sir, Dr. Prajakta Patil, madam, for technical support and all help. Last but not the least, audience, and now with due permission, all the dignitaries, I am concluding today's webinar. Thank you for attending and hope you all enjoy this today's knowledgeable lecture. Thank you so much.
You. With permission of all dignitaries, I will leave.